Very interesting to listen to that play out on the legal front, to hear Mark O'Mara really go through the litany here, the step-by-step process. But at the end, he said it depends on how the state handles their case and whether or not this would even come up. We have our experts with us. Mark NeJame, HLN legal analyst, great attorney. Mark Lyons with us as well, criminal defense attorney. Mark NeJame, so let's help us all understand. What would the state have to do to where this could come in about Trayvon Martin and allegedly being involved in fights in the past?
Basically, just bring up areas such that he's got a peaceful nature, that he was a sweet, innocent kid, anything that might open up the door that allows the defense to come in and counter it. And that's, I think you're seeing the back and forth, the juxtaposition where they're trying to put one against the other. Basically, if in fact the case is limited to the facts of that particular evening, I think the defense is even acknowledging they can't get in a lot of this area. But now they have a ruling, even though it seems like it's against them on the motion in limine, it basically says if the state opens the door, then the defense might be able to bring in these other areas. So the state's going to have to be very vigilant throughout this case to make sure they don't open up the door and stick to the facts of the case, because otherwise some of this might come in. Okay,
so Mark Lyons, again, the door's cracked there. If the state does, as Mark NeJame said, if the door opens up at all, then some of this could come in. But what Mark O'Mara said was that they want to really, everybody wants to focus on the 6 or 7 minutes where this all went down. So this could be a short trial if they just do that. Am I right?
It could be a short trial. I don't think it's going to be. I think ultimately the court's going to rule that some of this expert testimony regarding the 911 tape is going to come in, and that may then, obviously, unfortunately, bore a lot of jurors and kind of be a situation where it's ultimately going to delay the trial longer than what it should be ordinarily. If this were a case where there were no cameras or otherwise, this case at most would take probably 5 to 7 days. Unfortunately for Mr. Zimmerman, this case may take longer than that.
Got it. Okay, guys, thanks again. You know, we're looking at all these rulings and parsing them out, because one of the headlines is bad day for George Zimmerman. Mark NeJame saying, well, not so fast. The door's still open. So that's the question to you. We'll take your calls a little later. 1-877-TEL-HLN. Big win for the prosecution or not. There's the number, 1-877-TEL-HLN. Again, this is the trial. You've got to see for yourself to decide. It begins June 10th. Our HLN trial experts are going to go back into court with the most comprehensive, detailed examination of the trial and the evidence and the killing of Trayvon Martin. And you know us. You know our passion. When we're in, we are all in. And that'll be the case in Florida versus George Zimmerman. Bottom line question, was it murder or self-defense? Watch it beginning June 10th right here on HLN. There you go. Ruling from Judge Deborah Nelson. Previously used marijuana allegations concerning Trayvon Martin. Not in the case, but the door is open a little bit. So let's get an explainer here from our experts. Back with us, HLN legal analyst and attorney Mark NeJame and criminal defense attorney Eric Schwartzreich with us as well. Mark, help our viewers understand where we are with this, because now it still could come in, right? But how could it come in? Help us out.
Well, the state was correct. There was 2 separate motion in limine, basically motion to keep evidence or information out of court. The first one, the judge was completely correct on. The prior use has really no relevancy or materiality to this case whatsoever. However, the second motion is what's the door still open on, and that is whether there was a present or a current impairment when the incident occurred, when the shooting occurred. And that is because the defense is claiming that part of their case in chief is that Trayvon Martin brought this upon himself, and in fact he might have been impaired, and in fact he might have been acting in such a way because of the purported or alleged drug use, which caused suspicion, which now makes George Zimmerman's questioning of what he was doing there, he being Trayvon Martin, more credible. So that's where the door is open. Basically, the judge is not going to let them talk about it in jury selection, but she will talk about general ideas and people's thoughts and beliefs about marijuana use, but nothing specific or somewhat analogous to this case. She's not going to let them get into circumstances about that.
Got it. Now, Eric, could the state, you know, basically potentially bring some of this in, basically to say, you know what, Trayvon Martin, he was fine. He wasn't impaired at all when this all went down.
State's got to be careful what they ask for, because if they open that door, then I imagine the defense is going to barge right through that door. State doesn't necessarily want that marijuana use in. Typically, character evidence does not come into evidence in a criminal case to show propensity, unless there's certain exceptions, absence of mistake, motive, identity, preparation, plan. But what's interesting about the defense's argument in wanting the marijuana in, I think that they do have an issue that George Zimmerman made a comment that he's acting strange, or perhaps I'm paraphrasing, and that he saw something, and that perhaps there was marijuana in his system. I think the problem for the defense is that we're dealing with marijuana. Whether or not he's chronic use and that affects his system and they get an expert, that's an interesting issue. But marijuana is not the same thing as cocaine or LSD. I think typically people will feel that marijuana slows you down or makes you more mellow or relaxed. But I don't know if the state wants it in, but certainly if I were the defense attorney and they're making a valiant effort, I would definitely want that in. And I think it's a great issue for them to have for appeal.
Yeah, a lot of our callers had said that, basically that observation that if marijuana does not make you more but less aggressive. But, you know, that's where experts come in, and that battle could continue.